Joining me now is George Zimmerman's defense attorney, Mark O'Mara. Mr. O'Mara, first, I want to thank you for coming on the show tonight, and I look forward to having a candid and respectful conversation about this case.
Thank you very much, Reverend. Great to talk to you.
Let's start with the night in question. Let's listen to the part of Mr. Zimmerman's, let's listen to part of the tape, of the 911 tape with Mr. Zimmerman and a dispatcher, when the dispatcher talks to him about pursuing Trayvon Martin.
Yes, sir.
He's running.
He's running? Which way is he running?
Down towards the other entrance of the neighborhood.
Okay. Which entrance is that he's heading towards?
The back entrance.
Are you following him?
Yeah.
Okay, we don't need you to do that.
Okay.
Now, how can Mr. Zimmerman claim self-defense if he was the one with the gun and he was the one pursuing Trayvon Martin, even after he agreed with the dispatcher who advised that he doesn't need him to follow him?
Well, the question is when he was pursuing him, and if he continued to pursue him, that's what a jury has to determine. The question is not really one of whether or not any pursuit at all then allows violent response. The Florida law, ignoring stand your ground because it doesn't really apply, but Florida's self-defense law says that you're allowed to respond to force with like force, and when that force gets to force likely to cause great bodily injury, then you can respond with deadly force. So if you suggest, well, Mr. Zimmerman was at least at one point pursuing or following Trayvon, then he can't argue any type of self-defense. That's just not the law. It really comes down to what happened when the two individuals got together, and what happened at that point, which would justify either one of them doing something to the other.
But you can't dismiss how they got together. And if they got together based on the pursuit of Mr. Zimmerman and a pursuit that he was advised by the dispatcher not to do, and which he agreed not to do and did anyway, that would also set up the framework of how they got together and what transpired when they got together. Then you can't come back with only one alive and say, I was defending myself.
I understand that perspective, but you have to understand that there is no evidence whatsoever, and the state has not brought forth any evidence to suggest that Mr. Zimmerman was following Trayvon Martin after the dispatch said you don't have to do that, because Ms. Zimmerman's answer was okay. There's no evidence to support that he continued to pursue. So I understand what you're saying if he did, but there's no evidence to support that.
Okay, so when he said okay, you're saying that that was, that he did not follow him after that? Is that what you're representing?
Knowing the evidence, I'm trying not to get into specific pieces of evidence that's truly for the trial, but to respond to your inquiry, there's no evidence that the state had. And actually, I asked the investigator at the April 20th hearing way in the beginning, I said, do you have any evidence to support that George Zimmerman continued to pursue Trayvon Martin? And he said no. I also asked the question, do you have any evidence to suggest that it was George Zimmerman who began the physical confrontation? And there's no evidence to that. Obviously, there is a gap of evidence or information, and we won't know. There was no videotape. We'll never know precisely what happened. But being that,
well, that may be why he doesn't. That may be why he said he didn't have any evidence, because there was only two people that we know of there, and one is dead. It's very difficult for him to get from the one claiming defense that kind of evidence. But all right, let's go to another piece of evidence that bothers a lot of people. A key evidence is the screaming heard on the on a witness 911 call, which the prosecution says is Trayvon Martin. Let's listen to that tape.
I think they're yelling help, but I don't know. Just send someone quick. Say stop.
Okay. Does he look hurt to you?
I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him.
So you think he's yelling help?
Yes.
All right. What is your phone number?
Just there's gunshots.
Now, both the prosecution expert and Martin's father say it's Trayvon on the tape. How can Mr. Zimmerman claim self-defense if Trayvon Martin is the one screaming for help?
Well, again, Tracy Martin, when he was first asked about that, said it wasn't Trayvon. And then at a later date, he said he listened to a cleaned up copy and it was Trayvon Martin, although there has never been a cleaned up copy. So I understand Tracy Martin's concern with having just lost his son, but that's to answer one part of it. You also mentioned that the state expert said that it was Trayvon Martin, and they actually didn't say that. If you look at the reports, they suggest that at times there was Trayvon's voice, and at other times, particularly before the shot, that it was George Zimmerman's voice. So I had mentioned before that I thought this case was going to be easy in the sense that I thought that tape was going to be easily determined to be one or the other screaming. I may have my thoughts, but my opinion doesn't matter. I thought it was going to be easy to find out who it was. All of the experts have suggested how difficult it's going to be to actually identify whose voice it is. There's none of the state's experts that have come back and said conclusively that was Trayvon or conclusively that was George. So that's another issue where, unfortunately, I don't think we're going to ever have precise evidence on it.
Well, Mr. O'Mara, you have the state that we are told has an expert witness that says this, as well as last year. Let's go to another source. The Orlando Sentinel, the paper in that area, had two experts say the voice screaming on the tape was not the voice of George Zimmerman. Now, there were only two people there. If it wasn't Zimmerman, then clearly it would be Trayvon. Doesn't that undercut your case if you have three experts now saying that it was not Zimmerman that was screaming for help that night? How's he defending himself if he's not the one screaming?
Well, again, respectful of your position and your insight, because you're entitled to it, I think the hearings that are going to be held next week, Thursday and Friday, the judge will have a better opportunity to see whether or not any of that evidence is going to come in. And then even beyond that, if it does come in, the jury is going to look at it, hopefully listen to the tape themselves, because they've got to make a decision not just on what they hear and what experts tell you, because I will tell you it's going to be across the board. But I will just let you know that's what all the experts are going to do. Then they're going to be across the board. But what they also have to do is take that evidence.
But the experts that we've heard from, go ahead, I'm sorry.
They also have to take that evidence in conjunction with all the forensic evidence. And as we know, that a lot of the forensic evidence suggests that though Trayvon Martin was fatally shot, he didn't have any other injuries that would suggest an altercation. Yet George Zimmerman had a lot of injuries which might suggest or show an altercation. So the jury's got to look at it all in at one context. We could take out little pieces of it. It just makes it difficult. But I agree. I thought that the voice was going to be easy to identify one or the other, and it's just not.
Well, we'll have to see at the hearings, but we have three public experts that say contrary to that. Let me go to another issue with you. On the night of Trayvon Martin's death, police let Mr. Zimmerman go. Many of us felt that that violated the rights of Mr. Martin, and which is why a lot of us became very interested in the case. Did they make the right decision that night to let him go without a full investigation?
Well, three answers. For those people who are very concerned in the way that young black males are treated in the criminal justice system, no, because it looked like they were just ignoring the fact that a young black teen was lost or killed and the guy went home. So from that perspective, no, they didn't make the right decision. From the perspective of looking at the statute that says if you have a belief that he acted in self-defense, you cannot arrest until you get to the point of probable cause. From that perspective, they did the right thing because they waited until they gathered more evidence to decide what to do. And that's not a bad thing. There are many cases where people are shot, people are killed, and arrests are not made. The third point is this, and as a former prosecutor, when you arrest, the 6 months speedy trial clock starts ticking. If you arrest on January 1st, you've got to try that client by June 30th. And if you don't, he could walk. So if, in fact, as a prosecutor, I would have said, don't arrest him until we actually have time to build our case, find out what's going on. We can always arrest. We know where he is, and we'll get to him to arrest him when we're ready to prosecute him. So three different perspectives, but I certainly understand all three. And if it was anything other than a concern for how the community was going to react, then I think the decision was probably proper to wait on the arrest.
But Mr. O'Mara, are you then saying that police should have the right to determine whether or not there was evidence of self-defense? Because you said that if they determined there was evidence of self-defense, they could not make the arrest. The police in a police station, whether the person is black, white, Latino, Asian, anyone is dead, how do the police then become empowered to determine whether it was self-defense or not when there's one person dead and the only other person there is the one that's alive? How do they become the judge and jury and the prosecutor of that?
Well, if you look at our statutes, and these are throughout the states, not just here in Florida, cops make decisions on probable cause every day. And every arrest, they have to look at it and say, is there probable cause here? Do I arrest you for a DUI because I have probable cause to believe you're driving under the influence? Do I arrest you for petty theft because I believe the witness who said you had it in your pocket? And in a murder case, we look at it and say, was your shooting of this person justified or not? I'll give you an example. If somebody came into your house and came at you, you have the absolute right. Now, you would have shot that person and killed him, and a cop would come to your house. You'd say, he was in my bedroom, I woke up, I had a gun, I shot him. Then the cop would go, there's no probable cause here for an arrest, and they would not arrest you, and they shouldn't arrest you. So take it out to
in my house, but we're not talking about in my house. We're talking about Trayvon Martin going to his father's house. He's dead. The police come. There's one shot. Mr. Zimmerman had the gun. How can the police determine, no matter what Mr. Zimmerman says, there's no probable cause when you have nothing but one shot, one man with a gun, and they were not in anyone's home. They were not in Mr. Zimmerman's area of that could have been violated by Trayvon Martin. How could they possibly predetermine that was self-defense?
Yes, Reverend. Earlier I was just mentioning that was an obvious example where you could kill somebody and there'll be not probable cause to arrest. But let's look a little bit closer to a case like the Zimmerman case. If there is, in fact, evidence that you acted in a way that was necessary to defend yourself. I mean, self-defense, and even killing somebody in self-defense, is allowable if it's justified. So when a cop looks at this, ignore the stand your ground law for a second, ignore 776 for a second, and just say, is there probable cause? May or may not be, and again, I think the idea of waiting until you build it up is better, but then if we add on our new statute passed in 2005 that says affirmatively, you cannot arrest somebody who acts in self-defense unless you determine probable cause. They are immune from prosecution. That in Florida actually increases the obligation on the police department to make sure they have probable cause before they arrest somebody. So
but
we do have a
you're saying that, but there's not probable cause when you have a unarmed person dead and the person there then decides that he's going to use a defense a self-defense defense to the police, and you're empowering the police to determine whether there's self-defense or not. The probable cause is you have a dead body of an unarmed person, and there was no crime, there was no reason that the police could determine at the scene. That's probable cause. I mean, otherwise, anyone in this country could be shot and killed, and the police could just decide in the police station, will decide whether they go or not. That's a very dangerous precedent. Wouldn't you think so, Attorney O'Mara?
I definitely don't agree with your perspective. I truly do, because what it seems like is that we're giving the cops too much power. And if, in fact, they could look at somebody, look at the circumstances, not do a good job of investigating, and say, you know what? That kid was black, or this guy is purple, or whatever it is, that's not probable cause, then you're right. That's an inappropriate decision. But I will say that if we give cops the opportunity to investigate crimes fully, and they actually do, then it's not a bad way to say you have to have probable cause. Now, here's a concern that I think is out there, and you just sort of referenced it. If you relate a dead body to probable cause, then yes, everybody who ends up causing the death of another should be arrested. But It is a slightly more cautious or difficult standard because when you throw on this defense of self-defense, and there are a lot of scenarios, not where you're just sitting in your house, but where you can say it is obvious this person acted to protect themselves. I'm not talking about this case right now, but any case where a person obviously had to act a certain way to protect themselves. In a rape situation where someone shoots somebody, no one would say that that wasn't appropriate then. So if we're talking about the gradations...
That's the problem that a lot of us have here. How can the police, given this circumstance, in this case, how can they determine that, there was a reason for this? And clearly when it was investigated by a special prosecutor, they found and charged differently. Let me ask you one other thing, and we're going to run out of time.
Yes, sir.
You put out a lot of stuff on Trayvon Martin that the judge did not allow, yet you say we should go by the 6 or 7 minutes of that night. Yet you put it out. You did not have to put this out in public. You could have waited until the hearing. Was this to try and poison the public against Trayvon Martin? And clearly your client's past, who had been arrested twice. Trayvon was never arrested. Your client was. That can't be brought up at trial. But you clearly put out things that stereotypes like gold teeth and all of that. What does that have to do with self-defense?
Okay, a couple of things. First of all, George was arrested once and the charges were dismissed, not twice, but not to get into that too much. The process was put in place by the prosecutor's office way in the beginning of this case where they put all of the discovery out on their website. They did that, and actually it made sense because that was easy access for the media. When we started getting up discovery, then we put it out on our website. Now let's talk about what discovery is and isn't. If I were to hold on to that information till a hearing or till a trial, if it doesn't get disclosed to the state, then it never can be used. So the filter is they have to give me everything. There's a bunch of information they've given me about George Zimmerman that I presume that they know is never getting into a courtroom. And there's a bunch of information about Trayvon Martin that I presume is never getting in a courtroom. But if we don't put out that first round of information, that discovery, then we can never use the more filtered round of what's out there. Now, if I wasn't to tell the state, hey, here's stuff we got off Trayvon Martin's phone, here's stuff we saw on Twitter or whatever, then no matter what happens, I can never use that. I've said it, and I'll say it here tonight. My hope still is that this matter gets tried in the 6 or 7 minutes of what happened from that non-emergency call to the end of the emergency call and what happened that night. But here's the problem. If the state goes into George's past, then I get to go into George's proper and positive past. If they say he's aggressive, I say he's peaceful. If they go into Trayvon's past, Trayvon is peaceful, I might be able to say Trayvon is aggressive. I truly hope none of that gets into a courtroom. This was a 6-minute event. But as a good criminal defense attorney, you have to be ready. I've got a lot of arrows in my quiver that I really hope they all stay there, and we try this case just on the facts of that night. But just like the prosecutor, has to be ready.
Well, I'm out of time. Clearly, we are going to disagree on the smears that was put out, in my opinion, but you've explained your legal position. I appreciate you coming on, and I hope we can have you back. Let me ask you this, though. The family of Trayvon Martin and the attorney for the family has said to all of citizens that they hope that they follow these proceedings in a civil matter and that we follow the letter of the law, and have even denounced when there has been people that have said things like rewards and vigilante justice. We've heard a lot of ugliness on the other side from even family members. Do you denounce the ugliness and say that we should proceed in a civil way and not in the ways of that we've heard on any side, and go through this process respecting the law, since it is a trial and justice that those of us that were concerned is seeking in this matter?
1,000%, sir. I'm very worried that we have tied way too much to this verdict, whatever verdict it is, that the country is getting divided by the case and that people are going to react negatively to it. So let me be very clear. This needs to be tried in a courtroom. It needs to be tried with the law and the facts of the case. And everybody, Even if they don't like the result, everybody's got to respect it. This is the best system in the world. It will lose its shine if we lose respect in it. So even though we've had troubles in the past, and you know them better than I, we have to rely on the jury system to do what it's supposed to do right and trust it and live with the result, whatever that is.
Well, I'll take that then that you agree with our actions because we fought to get it in a courtroom, not a police station to determine that. So I
agree with
accept
that.
your endorsement of our rallies. Thank you.
I absolutely agree with that.
Thank you for your time. And in full disclosure, in civil court, George Zimmerman has sued NBC Universal for defamation, and the company has strongly denied his allegations. We hope to have you back and continue these very frank conversations, as well as with Mr. Crump. We'll be right back. In 11 days, George Zimmerman will go on trial in this state. He has the right to a defense. He has a right to explain his actions. But Trayvon Martin also had rights, and many people around the world of all races, including me, said that the police should not be able to go beyond those rights. And that's what many felt when he was released, George Zimmerman was released, and this was not tried in a court of law. Now it will be in a court of law. And even Mr. O'Mara said that's where it should be. Well, I'm not sure that that would have happened had not the public said, wait a minute, everyone's rights, Trayvon Martin's rights, cannot be violated. I hope that we have a fair and just trial, and we'll be watching that. But I hope the public will not use this as a way to go beyond the means of law. I hope that the law will stand up for what is right, and we see that we live in a nation where people cannot just do things and walk away with it without being held accountable. It is important for this nation that we watch and see how far we've come. That's why we needed to go in a court of law, and that's what we sought. And in 11 days, that's what will begin to happen. Thanks for watching.